Uh-oh. Okay. All right. Hello, everybody, and welcome to today's webinar. My name is Gail Schwartz with the Housing Alliance of Pennsylvania. Thank you for joining us for today's webinar on criminal history and tenant selection 101. To let you all know, this presentation is being recorded and will run approximately 60 minutes, including question and answer time. We will also send you a link via email to this recording in the next few days, as well as upload it to our YouTube channel and post it on our website. Attendees will be muted during the presentation. If you have a question for the presenters, please type them in the Q&A box in the bottom of the screen. If you have a logistical question for Housing Alliance staff, please use the chat feature. The chat feature should not be used for questions to the presenters. And with that, let me hand it over to Laura Schwartz with Regional Housing Legal Services to get this presentation started.
Okay. Good afternoon to everyone. I promise that you will hear from people today who are not named Schwartz. We will get to non-Schwartzes eventually. I just wanted to welcome everyone and thank you for spending this hour of your lockdown with us. Let me just get this. There we go. Okay. I am an attorney with Regional Housing Legal Services, and Regional Housing, and as part of my practice, primarily represent nonprofit organizations that develop affordable housing using the low-income housing tax credits. And for those of you who are not aware of it, over 90% of the affordable housing developed in the United States is developed using the low-income housing tax credit. However, what you learn today is not only applicable to that type of housing, it applies to all rental housing. So whether you own or manage a low-income housing tax credit funded project or not, you will learn what you need to with respect to criminal record screening today. When we were putting together this workshop, we knew it would be relevant, we knew it would be timely, but I don't think any of us knew how relevant and how timely it would be. And that was because in the midst of, as we are in the midst of the worldwide pandemic, across the United States, jails and prisons are releasing inmates, mostly those that are at the end of their sentence or are nonviolent offenders, or in the case of jails, being held over for bail. This is true in Pennsylvania as well as elsewhere. And I know that in Allegheny County, they've released about 700 prisoners, a quarter of the jail population. And that's true in Lancaster and Berks as well. And with respect at the state level, there is legislation pending that will determine what happens with that. So if you are the owner or property manager of any rental housing project, you know all too well that you have to comply with a lot of laws and regulations, and that the penalties for not complying with them, with any of the laws or regulations, can be very serious. So how do you stay out of trouble and how do you stay out of court? The first thing is to understand, and the most important thing is to understand the rules that apply to you. And very often the rules are changing that apply to you and the units you own and manage with respect to tenant screening and criminal records. And then once you understand the rules, to use the best practices. And you're going to hear about some of these best practices today. And in fact, you'll get a copy of one of them. First, you are going to hear an overview about the scope of the problem in the United States. We have the highest rate of incarceration and the world's largest prison population. And in fact, Pennsylvania, if it were its own country, would have a higher rate of incarceration than any other country in the world. At the same time, 95% of the people in prison today will be released. And finding affordable, decent housing is going to be and is the most critical factor to their successful reentry. So first you're going to hear from Carolyn Steinhofer. Carolyn is an intake and outreach coordinator of the Housing Equality Center of Pennsylvania, which is based in Montgomery County here near Philadelphia, and is the oldest fair housing council in the country. She is going to talk about who goes to prison and what any of this has to do with fair housing law. Second, we're going to talk about how you can avoid litigation for rental decisions that involve applicants with criminal records. The best defense is to have a good screening policy and to follow it. And for that, you are going to hear from Sarah Pratt. Sarah is a civil rights litigator who developed the screening policy that is widely held to be the gold standard. And prior to that, she was Deputy Assistant Secretary for Fair Housing at HUD. So with that, Carolyn, take it over.
All right, thanks, Laura. So in 2016, HUD released guidance on the application of Fair Housing Act standards and the use of criminal records by providers of housing and in real estate related transactions. So we're gonna go over that, but basically, just to repeat what Laura said, about 100 million US adults have a criminal record. That's about a third of the population of the United States. And across the United States, African Americans and Latinos or Hispanics are arrested, convicted, and incarcerated at rates that are disproportionate to their share of the general population. So consequently, criminal records-based barriers to housing are likely to have a disproportionate impact on minority home seekers. So, for example, African Americans represent 12% of the population of drug users. However, they represent 38% of those arrested for drug offenses and 59% of those in state prison for drug offenses. If you look at the U.S. Census data from 2014, and you look at the population of white, African American, Hispanic, and other, and then contrast that on your right to the U.S. prison population, you can see the stark differences in making up what is made up with our general racial population as opposed to the prison population. So the lifetime likelihood of imprisonment, I'll give you a minute to look over this. For all men, it's 1 in 9. For white men, 1 in 17. Black men, 1 in 3 lifetime likelihood of imprisonment, and Latino men, 1 in 6. And down at the bottom is the data for women. For all women, 1 in 56, white women, 1 in 111, Black women, 1 in 18, and Latino women, 1 in 45. So over 95% of these inmates are going to be released at some point, and they're going to be applying for housing. So we need to consider that all criminal records are not the same. So you have to look at, has someone been arrested or have they been convicted? That's not the same thing at all. Do they have a felony? Do they have a misdemeanor? Perhaps it's just a summary offense. What's the length of time since the crime was committed? And what's the severity of the crime? So blanket bans stating that we will not rent to anyone with any type of criminal record, no matter when the conviction occurred, without considering anything that the person has done since then to rehabilitate themselves, will be unable to meet the burden of proving a substantial, legitimate, non-discriminatory interest. So the HUD guidance states that decisions have to be made on a case-by-case basis. You must consider the nature and severity of the conviction and the amount of time that's passed since the criminal conduct occurred. So research shows that over time, the likelihood that a person with a prior criminal record will engage in additional criminal conduct decreases until it approximates the likelihood that a person with no criminal history will commit an offense, and that's about 6 to 7 years. So if someone hasn't reoffended within the past 6 to 7 years, they are about as likely to commit a crime as someone who's never committed a crime. And that'll become more important to you when Sarah talks about her screening process. So you want to look at an individualized assessment of information. So you want to look at the facts and circumstances surrounding the criminal conduct, the age of the individual at the time the conduct occurred, the evidence they've maintained a good tenant history before and after the conviction or conduct. I think we all know people who do not have a criminal record who are terrible tenants. So the criminal history is not correlated with whether they're going to be a good tenant or not. And there's evidence of rehabilitation efforts. These are all things that should be taken into consideration. There was a landmark case that was filed in October 2014. Fortune Society is an organization which assists people who are formerly incarcerated, assists them with employment and start seeking housing. And they were looking for housing to house some of their clients at Sandcastle Towers, but Sandcastle Towers had a policy that they would not rent to anyone with a criminal record. So that was a precedent-setting $1.2 million settlement. It was a landmark, a federal civil rights case. And basically that established that, lawsuits can be brought against private landlords who impose blanket bans on renting apartments to people with criminal records without taking into consideration the nature of the crime, the severity of the crime, and the recency of the crime. So HUD has already issued guidance on prior arrest. So HUD guidance for public housing agencies and owners of federally assisted housing states that arrest records may not be the basis for denying admission, terminating assistance, or evicting tenants from public and other federally assisted housing. The Supreme Court has established that the fact that someone's been arrested does not prove that they actually engaged in any misconduct. It's just the fact that someone's arrested shows that somebody probably suspected that person committed the crime and they were apprehended for that offense. So exclusions because of prior arrest will not be able to show that you're actually protecting other residents' safety and or property if they have not been convicted, if it's just an arrest. So there's an exemption from this liability under the Fair Housing Act, and that is that if someone has been convicted of the illegal manufacture or distribution of a controlled substance, then housing providers will not be liable under the Act for excluding those individuals. So regardless of any discriminatory effect that may result from such a policy. But please note that that is a conviction for drug manufacture and distribution only, and it does not include arrest for such offenses, and it does not include conviction for possession. So there's also a disability component to this that you should be aware of. So the Fair Housing Amendments Act is a very broad act which defines disability very broadly as a physical or mental impairment that substantially limits one or more of a person's major life activities. And major life activity is walking, talking, seeing, hearing, breathing, working. But it also includes people who have a history of an impairment and people who are perceived as having an impairment. And that includes those recovering from addiction. Now remember, current users of illegal drugs are not covered. But the Fair Housing Amendments Act requires housing providers to make reasonable accommodations for people with disabilities. A reasonable accommodation is a change in a rule, policy, practices, or services to enable a person with a disability equal opportunity to use and enjoy a dwelling. And how does that correlate to criminal records? Well, if an individual has a criminal record due to conduct that directly resulted from a mental health disability or an addiction, if they can demonstrate that they've received treatment or that they are now on new medication that has eliminated this behavior that led to that criminal conduct was unlikely to reoccur, that individual can request a reasonable accommodation to your application criteria, to your ordinary criteria regarding criminal record and say, listen, I have disability, this directly caused this criminal behavior, please, I'm requesting a reasonable accommodation to your ordinary application criteria. So with that being said, the Fair Housing Act does not require that housing providers rent to anyone who constitutes a direct threat to the health and safety of others or a risk of substantial damage. We're not saying that you have to rent to Charles Manson or the Unabomber. or someone who has a very recent history of committing arson, for example. Housing providers, you may not deny housing to people with disabilities based on fear or speculation or stereotypes about a particular disability or stereotypes about disabilities in general. And if you will be denying housing or evicting someone because of the fear that they will be a direct threat to the health and safety of others or your property, that must be based on reliable evidence and on objective evidence. So you have to take into account the nature and severity of the risk of injury, as well as the probability that an injury will occur, and whether there are any reasonable accommodations that would eliminate that direct threat. So even in cases where tenants in fact do present a direct threat due to a disability, they're entitled to determination whether any reasonable accommodation would mitigate any risk posed by their behavior prior to eviction. So in conclusion, because of widespread racial and ethnic disparities in the U.S. criminal justice system, that criminal history-based restrictions on access to housing are likely to disproportionately affect African Americans and Hispanics. But the Fair Housing Act does not prohibit housing providers from appropriately considering criminal history information when making housing decisions, but arbitrary and overly broad criminal history-related bans are likely to lack a legally sufficient justification. So discrimination resulting from a policy or practice that denies housing to anyone with a prior arrest or just any type of criminal conviction cannot be justified. That type of blanket ban policy violates the Fair Housing Act. So policies that exclude people based on their criminal history must be tailored to serve the housing provider's substantial, legitimate, non-discriminatory interests and take into factors such as the nature of the crime, the severity of the crime, the recency of the crime. If you're only excluding individuals with certain types of convictions, you'll still bear the burden of proving that any discriminatory effect caused by that policy is justified by a connection to being a successful tenant. So make those determinations on a case-by-case basis. Selective use of criminal history based on race, national origin, or any other of the state or federal protected classes would violate the Pennsylvania State Human Relations Act or the Federal Fair Housing Act. So these criminal history-based evaluations need to be applied uniformly to everyone without regard to race or national origin or any other protected class. You can find more information on our website, equalhousing.org. You can sign up for our newsletter, request information, request training. And if you would like to contact me for any questions, here's my contact information. It's my last name, Steinhofer@equalhousing.org, and you can reach me at extension 2. And so I will stop sharing my screen so that Sarah can begin sharing.
Sarah, you are muted. Can you please unmute yourself?
All right, there you go. Can you hear me now?
I can, thank you.
So thanks everybody for joining this afternoon. You know, I have a number of friends who are young people. They're in their 20s, and they are all young people of color, and 80% of them have some kind of criminal background. They're all perfectly nice kids. Most are in school or have graduated from school. Some are artists, some are firefighters, some have other training or experience. They're all working. But 80% of them have a criminal background. Maybe it was a driving while black kind of driving conviction. Maybe it was shoplifting. And one of my young women friends shoplifted or tried to shoplift a coat for her then boyfriend and got caught. Another young woman was charged with loitering when she was part of a larger group that the police were asking to leave a neighborhood late at night. I found that these young people, all good, solid people as I know them, don't even know many times whether they have an arrest or whether they have a conviction or whether their charges might even have been dropped. They have no idea because of their interactions with the justice system have themselves been so confusing to them, and they have not understood them. And so one young woman I know disclosed in an application to be a massage therapist. She had genuinely completed the training. She was starting to be a massage therapist with a business. And she reported on her application for this job that she had a conviction of a crime, and it stopped her licensure application. But it turns out she did not have a conviction of a crime. She was confused. She was arrested, but the charges were dismissed. And so the first thing I want to say about this is asking someone whether they've been arrested or convicted of something may not give you an accurate answer as to what actually happened. Now, I know most of you use third-party screeners in evaluating and getting information about criminal backgrounds, but asking people is not very reliable as a way to get information. So I did work when I was at HUD on the guidance pieces that many of you are familiar with. I am not going to read them to you. I'm not going to talk to you about them. I think anyone who has to read a HUD memo written by lawyers has experienced a serious penalization. Those guidance pieces are difficult to read and hard to interpret, and they don't always tell us what to do. When I was at HUD, I did often argue, can we just do a sample policy and give it out? And people say, oh no, the lawyers say, no, we can't do that. But the answer often for people who are working in small organizations and do not have legal lawyers, that they don't have a comprehensive approach to these kinds of issues, and they don't have an easy way to get an answer to a specific question. So what I'm going to try to do with my time today is give you a little bit of different kind of background than the background Carolyn gave you. And then I want to talk about what a policy might look like and why it might look that way. And then part of the materials that you'll have access to after the webinar is over includes a sample policy that came out of a lawsuit that where I represented a fair housing organization against a landlord. So I want to start my presentation by talking about the research that has been done, and it's not a lot, about what happens when people come out of prison or jail, out of a period of incarceration, and what kind of tenants they actually make. So there's only 2 studies, and Carolyn cited one, the one that was done some time ago, that says the chances that you will recidivate as someone having a criminal experience with the criminal justice system at about 6 or 7 years, the chance that they will do it again is roughly the same as if you or I were going to go out and commit a crime. In other words, it's the risk drops dramatically at the 6 to 7 year period that the person is any kind of a risk. But the study that I have found most interesting is a study that was commissioned by 4 nonprofit landlords in Minnesota based on their own data. So they had been in a situation where they had rented to people with criminal backgrounds, and they collected a lot of data, and they did a very detailed analysis. And read it for yourself. There's a link at the bottom of the PowerPoint. You can go take a look at it. But the key takeaways from this study is, for the most part, a criminal background just by itself of any type had little effect on someone's successful tenancy. So a criminal background, whether or not someone had a criminal background, was not a predictor of whether someone would be a good tenant or not. So here's some of the specifics. They looked at a large number of criminal offense categories. Most places have some kind of blanket policy. No felonies, no misdemeanors, no felonies within the last 99 years. I mean, really? Okay. So 11 of 15 criminal offense categories had no significant effect on housing outcomes. So look at these: marijuana, DUI, alcohol-related offenses other than DUI, minor public order trespass offenses. I got a call from a guy who had an offense he was charged with and convicted of. Basically, he did he said he admitted that there was enough evidence to establish his guilt for being drunk and disorderly on the beach during spring break, right? And he was turned away from housing because of that. Other minor drug-related offenses, including some that are now possession of marijuana and some other offenses that are legal in many places, disorderly conduct, prostitution, even domestic violence and other kinds of violent offenses often do not, all of those, or none of those have an effect on someone, whether or not someone's going to be successful as a tenant. There are 4 categories that do have a significant effect based on this study, and it makes sense. Each one of them makes sense. Fraud, right? Like writing bad checks, or defrauding a bank or a credit card company. Assault, which is hitting people basically, right? Or threatening, getting up close and threatening to hurt someone. Property offenses, things like battering down the door or tearing down a fence, and major drug-related offenses. So for those categories of crimes, those are the ones that you can reasonably say may make a difference as to your experience with them as a resident or as a tenant. Now, let's go to the next slide and look at this one, which is the one that I found the most interesting. If someone has a misdemeanor conviction, the effect of that on your ability to be a good tenant declines after 2 years from the date of the conviction. And the effect of a felony conviction declines actually after 5 years, so that to a level that it's no longer a risk. So in both of those categories, for misdemeanors, more than 2 years after the conviction, not a risk. Effect of a felony conviction after 5 years, not a risk. So, so this research has been somewhat widely distributed, but it's interesting because it is nonprofit landlords. It is nonprofit landlords aware of and wishing to house people who have had experience with the criminal justice system or who have been incarcerated, but really wanted to see what their risk was. And that's why I like it, because it gives you an indication of what the risk really is that you may be thinking about or dealing with. So Carolyn went over the guidance pieces that HUD has issued. HUD has actually issued 3 different pieces plus some questions and answers. The initial one, which turned into a notice, is for HUD-funded housing. And it is a little bit more vague, and that's because HUD has had regulations for a long time about criminal backgrounds, and the notice had to work around what HUD says about the regulations. But then HUD later issued an opinion of the General Counsel that is binding on both HUD-funded properties and on private landlords interpreting the Fair Housing Act. And Carolyn has given you some really good tips and pointers about what this guidance, these guidance pieces tell us. What I'm going to do is just summarize for you the takeaways. So this is like the short list of first I have the do nots, and then I have the do's. So the first do not is don't rely on the fact that someone has an arrest to say I'm not renting to you, or I'm gonna kick you out, either one of those things. For the reasons that Carolyn mentioned, having an arrest is not evidence of really much of anything. Now, I will tell you that there are some situations where you have a person who is a current tenant and they have been arrested and you have evidence of the behavior, not just you didn't hear that they were arrested, because just hearing that they were arrested is not enough for an adverse decision. But maybe you have evidence, the police report, you've interviewed tenants, you saw it yourself. When you're taking action in that situation, you're not taking it because of the arrest. You're taking it because the tenant pulled a knife on somebody and threatened to slash their throat. that's evidence of bad conduct, and you don't have to rent to them anymore. And you can ask that person to leave. You can separate them out, keep the household, and ask that particular person to leave. You don't have to evict the whole household. And some of us think that if you tried to get rid of the entire household because of the current bad conduct of one resident, you might have a number of legal challenges on your hands. So this means also not just how you make decisions about arrest, because you should not decide to exclude somebody from housing because of an arrest. The next question is, well, what about those applications that ask everybody, do you have an arrest, do you have a conviction? Well, it's not illegal to ask someone if they have an arrest. But people are going to say, why the heck are you asking if someone has ever had an arrest if you cannot use that against the people? So just you better have an answer for that is what I've got to say. What about those people? This is one where I think it's a little bit harder. So I know landlords say, oh, we asked them if they had an arrest on their record and they said no, and then we ran the criminal background and look, they have an arrest. So we're going to turn them down because they lied on the application. Can I just say that's got a yellow light attached to it? That's a cautionary response to you who think I'm gonna address this by taking action against someone because they lied about the application. If you're not allowed to rely on the underlying information about whether or not someone has an arrest, then lying about it has not much relevance at all. And I think many judges would say, no, you can't take an action for someone lying on the application on an issue that's not really relevant and that you're not permitted to consider because HUD says you're not. What about this blanket ban stuff? You know, the Sandcastle case was a lawsuit that my law firm handled. We represented the Fortune Society, which is a well-known nonprofit providing housing for people leaving incarceration in the New York City area. And they had a blanket ban, we alleged in the lawsuit. And as you heard from Carolyn, there was a significant large settlement ultimately in that case. They had a blanket ban and they banned anyone who had any kind of felony conviction. And that blanket ban sweeps too broadly. It knocks people out who would be very well qualified. My example for that is, well, so somebody has a conviction of, I don't know, maybe they were Mother Teresa and they were, or Dorothy Day, and they were sitting in as and conducting a demonstration for peace, and they got arrested and convicted of trespassing. That somebody you want to exclude from your apartment or complex, or maybe you'd actually prefer to have them be a tenant. So my general rule about this is it sweeps too broadly. Don't just have a blanket ban on felonies, on misdemeanors, and not even on particular types of felonies or misdemeanors, and I'll explain more in a second. So don't use an unreasonably long look-back period. Honestly, I've looked at so many of these policies, and some group of lawyers must be advising a bunch of landlords because they all have 99-year look-back periods in their policies. And I'm like, who thought of that? Because, I mean, I guess that is some smart aleck response to the idea of you can't have a blanket ban on felonies completely, so we'll just make it a 99-year look-back period. That's fine. But that's not a good idea. It's not a good idea for the landlord. It's not, because it is too broad, and it's not good sound legal advice given the status of the data and the analysis that Carolyn went through a few minutes ago. Now, even a 20-year look-back period is very troubling, and even a 10-year look-back period may be troubling, except perhaps for the most serious of crimes. More about that in a minute. I think it's also important that you not consider having the same look-back periods for all kinds of convictions, for felonies and misdemeanors. I think that that kind of analysis does not take into account the relative severity. A felony is a more serious crime. A misdemeanor is a less serious crime. And having the same look-back period also for all kinds of crimes, whether it's the misdemeanor of leaving the scene of the accident, or the DUI, the first DUI offense that someone pled guilty to, as opposed to a felony that involved robbing a 7-Eleven. I mean, those are just different crimes, different context, and different considerations that you're going to want to put into play. Here's one of my least favorite cases of all time, and I've seen it 3 or 4 times already. Do not evict a successful tenant because you discover a conviction on her or his record after admission, and especially not after years of successful tenancy. Honestly, the worst story I've heard about this one was a woman who lived on the 2nd floor, and she'd been a tenant there in the property for 3.5 years. And she was aging in place, and she was having more and more trouble with the steps. So she requested, now listen to this, the reasonable accommodation of a transfer from her 2nd floor unit to a ground floor unit. And for some reason, and this was a tax credit property, but I've been advised by my friends who do tax credit work that there's nothing in the tax credit rules required this. The property treated her as a new applicant and ran a criminal background check, which they had not done when she initially moved in. They did a criminal background check where a successful tenant was transferring as a reasonable accommodation to a ground floor unit because of her disability. And they found a conviction, and they threatened her with eviction. And it was only because of a fair housing group got involved, and they had competent legal counsel advising them. And they sent a letter to the landlord saying, if you evict, we've got a fair housing fight that we're going to pick with you about this. Because it was not only a conviction for shoplifting of something under $100. It was a minor crime, but the woman was a good tenant. And yet somehow people thought under their policy they should evict her. Carolyn pointed out the disability issues. Don't forget to think about reasonable accommodations if you are aware that the applicant or the tenant has a disability, regardless of the conviction, and maybe offer the opportunity, as I'll discuss later, through an individualized assessment for the person to raise it. So those are the don'ts. There are some do's as well. So none of this will be a surprise to good managers. Do have a clear policy. Know what your policy is and apply it consistently. And by the way, train your staff on how to apply your policy. This is so true. Carolyn raised this point, and I really want to amplify it for you because there have been 2 local studies, audits of practices of landlords in 2 different parts of the country. And in both of those studies, up to 50% of the time, here's what happened. 1, the on-site person either didn't know the policy or was deliberately treating applicants differently, because up to 50% of the time, the white applicants were told, oh, go ahead and apply, honey. You never know what they're going to come up with on these analyses. And the black applicants were told, don't bother. I don't want to have to take your money because we can't refund your application fee. We think you'll be turned down. That kind of fairly significant unequal treatment that showed up so often tells me 2 things. 1, the staff doesn't understand the policy. And by the way, some of the evidence was that the staff told black applicants the wrong policy and more strict policy than was actually in effect. And 2, the staff are not applying the policy consistently. They either don't understand it or they're deliberately not applying it consistently. And that will end you up with a civil rights complaint quite easily. And in fact, a number of the cases that I've seen so far have been based on comparable treatments. So you have an African-American reports, this is what they were told, we find the policy, and then someone sends out a tester who's white, and they have their story, and we compare how the treatment occurs. Do in your policy consider the conduct that was underlying the conviction more than the fact of the conviction. And back in the day, we didn't have access to criminal backgrounds. Does everybody remember when that was? I certainly do. I talked to a lot of landlords and I had a lot of experiences. And for back in the day, we didn't have criminal background policies. How did we find out about whether somebody was going to be a good tenant? Well, if we did anything, we called their last landlord and asked them how they were as a tenant. That's how we found out, because we were looking for conduct. How did they behave? Number one question was always, did they pay their rent on time? Right? Nod your head, because I know that was the first question, and so do you. And the second one was were they a good tenant? And if the answer was yes to those questions, that was it on conduct. So the fact that we have more access to more information is good, I guess, in some ways, but it also reminds us that we have to be careful about how we use data and information. So I want, the final bullet on this page is the most important probably of all of them, and that is, do have the policy that allows everybody that you intend to, that you have a concern about based on their criminal background, do give every one of those people the opportunity to make her case for either admission or for continued tenancy before you reject them, not afterwards. Now, why? Well, I'll explain a little bit more in a couple of minutes, but the bottom line is you want to make sure, one, that your facts are correct, and two, you want to hear their side of the story. That doesn't mean that you will change your mind, although you might, but it does mean that you want to make sure that you have all of the valid reasons and all of the valid issues that you want to consider in your mind before you make your decision. And that's why taking that action before you turn the person down is the best practice in this area. And that's part of this idea of an individualized assessment. I have heard so many people say to me, oh, well, the Fair Housing Act is all about treating people the same, and you just can't make exceptions, and you got to treat everybody the same. And I just wish I knew who was doing that training, because that's not what I ever said. I mean, yes, in some cases it is about treating people the same, but sometimes it's using your common sense and paying attention to individual circumstances. We recommend that the person who makes the individualized assessment that HUD recommends as a appropriate step not be the person who made the original decision, but if you have multiple properties or multiple decision makers, it should be somebody other than the original decision maker. And that is to help make sure that the outcomes of individualized assessments are consistent from one situation to the next. All right, I'm just wandering along here. So now is the time to tell me about this case. I'll tell you about this case. So I left HUD in 2015, and now I'm working for the law firm of Relman Colfax, as you can tell from the PowerPoint presentation that I'm doing on their template. But this lawsuit, I represented a private fair housing organization in Virginia. I will just say I'm going to talk about a couple of Virginia cases which are relevant to Pennsylvania because you're near neighbors and in the same court of appeals. So this lawsuit resulted in the adoption of a policy that we worked hard on with opposing counsel, a woman named Thre, to try to get to a policy that we thought would work for the landlord and would work for the civil rights advocate. So let me tell you a little bit about this. More details about this are in handouts that will be available to you, including a copy of the actual policy. So the first is, here's the lawsuit. It was Sterling Glen Apartments in Chesterfield, Virginia. It's a 300-unit private market apartment complex, and here's their policy. They were not allowed to rent to someone who had any kind of felony conviction, any terrorist-related conviction, any illegal drug-related conviction, any prostitution-related conviction, any sex-related conviction. I didn't ask what that meant. Can you see this? Any cruelty to animals, or any of the charges where it was adjudication deferred, and also being on active status on probation or parole. Now, being on probation and parole at the very least means that somebody's out of incarceration or never had to be incarcerated, and they're just under light kind of supervision from, state and local officials. If anybody had an incentive to behave themselves, it's somebody who's on probation or parole. And if anybody had an incentive to behave well so they could have an apartment, since having a stable living environment is critical to those people on probation or parole, this is someone who has an extra incentive to behave themselves. That's my point about that. By the way, don't ask me. I do not know where the cruelty to animal related conviction came into play. No idea. Okay. So we settled this case using a policy that has 3 simple steps. So the first thing is you qualify the household based on income and credit score, whatever the criteria are that you use routinely. And that is to avoid, having to look at the criminal background for everybody. If somebody's you're gonna reject somebody because they're not making enough money, you can stop there, right? Or they don't have a high enough income to afford your apartment, you can stop. So qualify the household on factors of income, credit score, if you use credit score or any other criteria. Now, why do we say given a tentative acceptance contingent on a criminal background check? You don't have to do that. But with developers that are doing business in a number of jurisdictions, we know that many cities have now adopted criminal background, ban the box ordinances for housing. Washington, D.C. is one of those places. And in a ban the box situation, they typically include a requirement like this, that you have to tell the person, yes, we're going to accept you based on income and credit, but now we're going to run a criminal background check. And so we put that in because developers may be doing business in multiple jurisdictions, and this provision will be consistent with ban the box ordinances in places where they may be doing business. Then you run the criminal check and you discover whether they have a covered criminal background. More about that on the next slide. If there is not a criminal background that is disqualifying, then fine, take them and house them. So that's a pretty quick process for most of your applicants. If there is a criminal background, offer the applicant in writing the chance of an individualized assessment and put it in writing. Okay. So here's the crimes that are covered by this policy. Felony criminal convictions within the past 5 years for significant categories of offenses. And the actual policy has footnotes that define each one of these in a little bit more detail. But and we did it with reference to crimes in Virginia. So property offenses, major drug offenses, fraud offenses, major violent offenses against persons, and sex offenses, that would be like rape or sexual assault. Right? Why did we pick those? Remember the Wilder research I talked about at the beginning of my presentation? Because these are the ones that indicated in the research that we have, there was a higher chance that their bad conduct reflected by this conviction would continue for at least 5 years. But if you have a felony conviction more than 5 years ago, you're not covered by the policy. And the policy says we're not covering charges or convictions or expunges convictions, doesn't treat people differently based on whether they're on probation or parole either. And then the policy says the applicant has 14 days to give information. They can provide whatever information they want to. Sometimes people want to show you probation officer recommendations or case managers, family members. Maybe they've been in transitional housing after incarceration and they have a good record there and they want to tell you about that. I've seen people who have had in these conversations said, this conviction, since this conviction, my life has completely changed, and then describe the job that they have and the life that they've had, their religious changes, their spiritual journey, their completion of being off drugs or being off alcohol. This is what they disclose to you as convincing you that they are a worthy tenant. You can do it by paper, you can do it by verbally. I recommend inviting them to submit paper if they want to, and have a call. And here's some evidence to consider. These are pretty much right out of the HUD guidance. I'm not going to go through all of them, but you know, it does make a difference if somebody was shoplifting for her boyfriend when she was 19, even if she was charged with something because she was a very expensive coat that is a felony. You know, it does make a difference that she was 19 and doing it for her boyfriend. It does make a difference if somebody was got charged with a felony of leaving the scene of an accident. They were put on probation right away, and they never did prison time, and they've got no record for any other reason. It does make a difference if someone has had really good conduct and has a good recommendation from their prior landlord or their transitional house. So these are things that you can invite and consider. I want to highlight a mistake was made. You know why? Because the first reported case under the Fair Housing Act was a person of color, who was turned down for an apartment, and the landlord had gotten the wrong information from the Credit Reporting Bureau. And it was mistaken identity. And they refused to listen to the guy when he said it was not him. And it was not him. And he did not have a conviction. And he had a successful Fair Housing Act case up in Illinois out of it. So mistakes are made sometimes. Notify the people in writing and keep the records. So this is, you know, straightforward stuff. I give it to you as an example of a kind of a policy that you could develop yourself and put in place yourself. I will say the disability case example that also comes from Virginia was where a mom was trying to add her son to the lease on her apartment. She was a perfectly good tenant. The son had a mental disability, and he had a misdemeanor conviction for indecent exposure. And the landlord turned the guy down. And the court, and this was litigated in Charlottesville, Virginia, court says, well, the crime itself is not a crime that presents a direct threat to the health or safety of other people. It's not nice, but it's not a direct threat either. And the son had gotten treatment. He hadn't had subsequent episodes. His condition was stable. Court says reasonable accommodation exception to the criminal background policy that the landlord had in place as a reasonable accommodation based on this.
Hi, Sarah. This is Gail. I just want to let you know we have about 7 minutes left and a few questions.
Yeah, no, that's great. Thanks for coming in and telling me. This slide is just the fact that for public housing and assisted housing, there are a few statutory exceptions, but I don't need to talk about them. So let's go to the questions.
I just wanted to add that for the LIHTC owners and property managers, with respect to the federal statutes, you are required to follow them if you have either an ACC or a RAD subsidy. And anyone that has questions about that can certainly contact me offline.
Great. So the first question that I see here is, are there laws that protect registered sex offenders when it comes to applying for housing?
So the laws that exist allow a landlord to restrict occupancy by a registered sex offender. And you'll see it on the second bullet on the slide that's up right now. Statutorily, federally assisted housing is permitted to exclude an applicant who has a lifetime registration as a sex offender. If the question is read the other way, what about somebody who's looking for that housing? Where should they live? The answer is, generally speaking, locally, there are typically some landlords who will accept those individuals under narrow circumstances and in smaller settings where there are no children, usually. And although they are not common, they do exist in most communities.
Great.
I just wanted to add that in Pennsylvania, our Megan's Law, I believe, does not have a lifetime sex registry. And most sex offenders that are on probation or parole have individualized restrictions, and they know what they are, and you can always contact their supervisor or their parole officer for the details of those restrictions.
Okay. The next question, we had a few on sex offenders, so I'm just wondering if maybe in the future we should just do a webinar completely devoted to that topic. And I'm making a note of that now because we do have several questions that are circling around that. So for those folks who asked, I'm going to kind of bypass them and get to some of the other issues in the few minutes that we have left. With that, the next question is, we have an apartment complex that does not allow people with pending charges to apply, or they evict them. Is that legal?
So given the disproportionality based on race and national origin of arrests, which is essentially a pending charge as an arrest where there has not been a final action taken. And I would say that essentially they are disqualifying people based on the fact that they've been arrested and have a pending charge. And that I would believe that that policy would be likely have a discriminatory effect on applicants who are Black and Latino, and would be ill-advised under HUD guidance about not making decisions just on the fact of an arrest.
All right. So our next question is, I do have tenants that have had convictions and they are good tenants. My question is this. One of my financial qualifications is that they work at their job at least 9 months. I believe that is legal. Just thought it would be a good idea to check. Is an employment requirement legal under fair housing?
Well, I'll come back and take a stab at this, although Carolyn probably has something to add. I would say that the requirement that someone have employment for 9 months before you rent to them is not about the criminal background as much as it is about the source of income. And source of income is now unlawful in a number of HUD programs and in some locations and in some states, and has also been challenged under the Fair Housing Act, not because it's directly illegal under the Fair Housing Act, but because discriminating against people about where their income comes from disproportionately disqualifies people who are on assistance, who have the right amount of money, but just receive it from government check. And so I would be cautious about your 9 month have to be working requirement, because I think someone could challenge us as discriminating against the applicant because of the source of their income.
All right, our next question is it okay for housing authorities to initially reject due to background and make the individual appeal to prove they should be accepted? Laura, you're muted.
Sorry. I think it's a bad practice. I think it's setting yourself up for liability without, when you say you're just automatically rejecting them. I believe that most housing authorities require you to look at mitigating circumstances at the same time, whether or not the person, I think you have to give them, the short answer is you have to give them an opportunity before you reject them. It's a good practice. And if you look at the, all housing authorities have what's called an ACOP, and which I forget what it stands for, continued occupancy, ACOP. And they have it, and they will list at the end what the mitigating circumstances are for applicants. So you really can't do that, is the short answer.
In the lease, it is often stated that the landlord can potentially evict based on multiple police visits to a unit. I've even seen landlords try to evict when a tenant had the police called on them for noise with no arrest or ticket or anything. Any advice on how to keep that out of the lease or what to do when that happens? Carolyn, you want to take a stab at answering this? I think you need to unmute yourself.
Sorry. Can you hear me now?
Yes.
Okay, so if the police are being called due to tenant behavior that is disruptive or destructive, that's one thing. But you have to be careful that that's not applied to victims of domestic violence. For example, if there is a woman with, you know, for example, with a PFA or an abusive spouse or ex-boyfriend, and she's calling the police due to being a victim of domestic violence, then she should not be penalized for those police calls.
So I would add to that a case against Norristown, Pennsylvania, for an ordinance that said landlords had to take action after 3 911 calls to a particular location, was successfully challenged both by HUD and by the American Civil Liberties Union as being discriminatory based on both race and gender. Domestic violence is one important example of why there might be repeated calls to a particular location because someone is calling for protection against an abuser that does not live there and they have no control over. And so I would be very cautious about this, using this repeated police visits to the locations as the basis for a decision. If there are other objective evidence about threats to the health or safety of a tenant or to the property, I would rely on those to take the action rather than just the number of police calls.
Great. So we're not going to quite get to all the questions, so I'm going to go through 2 more, and then we can do the best to answer.
Gail, I just did have one thing I wanted to bring up and exercise my prerogative to do it. I hear a lot from property managers and owners, and it's what my father would have called an apocryphal tale, I think. If I rent to an ex-offender, my insurance will go up. If I rent to an ex-offender and something goes wrong, I'll get sued. I have never seen evidence of that, and I've spoken to insurance agents about it and said, you know, does it affect your property insurance? I've never heard that it does, but it is hard to prove a negative. So I would ask the panelists if they have anything to weigh in on that.
I've seen the defense, I've heard the defense raised many times about if I do this, I'll get sued or somebody will hurt themselves. I've never seen a case where I believe that actually happened. And when we've gone further and talked to insurance companies deny any knowledge of such policies.
Okay, good. It's good to have that affirmed, because that's been my experience in talking to insurance agents. It's like the giant alligators in the sewers. Everybody's heard of it.
Okay. I have this one last one. Is there any information about excluding a person that has a PFA against them or checking if they have one? I'm assuming this is when somebody's screening a potential tenant.
Sarah, what's your take on that?
I don't know what a PFA is. That's a Pennsylvania term, I guess.
Oh, protection from abuse order. It's a restraining order.
And the idea of evicting someone who has a PFA against them? Or
it just says excluding a person. So I'm assuming in tenant screening.
So we see that in landlord-tenant situations all the time, where there's a domestic violence situations where there's an abuser and someone who is being abused. The abused person is the tenant. The abuser is either lives there or is a visitor. And having visitation restrictions have been used to either get the person off the lease. So you separate the lease or sequester the lease, keep the victim on the lease and get rid of the person on the lease who was the abuser, or you can do no trespassing or no entry rules or policies against them. Those policies are not always successful because, of course, people come in the middle of the night when nobody's around and continue their abuse. But evicting someone or taking action against someone because they have sought a protective order is clearly inappropriate because they are the victim. But someone who is the subject of a protective order, I would address myself to the evidence under the PFA, the evidence of bad behavior, conduct, in other words, and look for evidence of the conduct and disqualify based on the conduct that was reported, not on the fact of a PFA.
Okay, all right. And this is going to be our last question, because I know we could be here all afternoon. This is such a nuanced topic, and we have such a great panel today. But what are good resources for doing a criminal background check, and how do you understand them?
I can just say I'm the wrong person to ask about that. There are numerous third-party black box, so-called black box screening companies out there. But the most important part is, if you're using a screening system, is that you are careful about what instructions you give them. In at least one case in Connecticut, CoreLogic is a company that has been sued for providing information on which adverse decisions were made based on criminal convictions. And the court there has said CoreLogic is also liable. So I think it's important to do a careful screening and to be very careful about the information that you as the landlord provide to the screening companies. Further than that, no recommendations.
Right, and I want to bring up that very often screening companies come up with, make mistakes based on similarity of names. They often pick up things that should have been sealed or expunged, so you shouldn't be making a decision based on that. And just to reiterate what Sarah said, you better be really, really careful what boxes you check. You can't just rely on them and check everything.
Great. So with that, I want to thank everybody who got on the webinar today. I know that there are some questions that have yet to be answered. So what we can do is share those questions with our brilliant panel and hopefully get answers that can be included with materials that are going to be distributed. And from there, clearly, we should do this again because it's a conversation that we need to keep happening, and maybe we can do something really diving deep into domestic violence related issues, as well as finding housing opportunities and effectively screening those who are convicted sex offenders. So we see this as the beginning of a conversation, not the whole conversation, and invite you all to come back as we continue to learn together the best ways that we can house the reentry population and serve the reentry population while keeping the broader community safe. Thank you. Thank you so much to the panel and to everybody on the call.